Thank you very much, guys. Hello, everyone.
And girls.
Yes, we've got all of you here today. It's a great pleasure to be here with you today to say a few words about cybersecurity from the legal perspective. Standing in front of you, being surrounded by IT people, IT experts, engineers, practitioners, all the software development people, means a lot to us. Today we're gonna talk about cybersecurity, so one of the 6 tracks of this year Code Europe, but we'll look at it from the legal perspective. So both me and Jędrzej decided to bring some extra value to the Code Europe, present slightly different angle, and we hope and we will try to keep this lecture as practical as possible. And maybe just to say a few words about ourselves, who we are and why these 2 white-collar people standing here in front of you and talking about the...
I've got stains from the coffee,
yes.
So, you know.
Why we are here. Maybe I will say about myself and then Jędrzej about himself. We are both lawyers. I'm attorney at law. Jędrzej is an advocate. And I consider myself, and maybe my market consider myself as internal lawyer, let's say in-house lawyer, because I have genuinely one client, international company, STX Next, with wide range IT services within our house. I cooperate with STX Next nearly 4 years right now, so I consider myself as a part of the structure. I know the company well, and I provide legal assistance to this company. And I'm an internal lawyer, and I will present internal perspective. And today with me is Jędrzej.
Yes, so Paweł is, like he said, he's an internal lawyer, so he's the master of procedures and the process. And I, as an external advisor, I'm looking for we can say, the problems from the perspective of external lawyers, so especially in terms of disputes resolutions, and avoiding the risk of the dispute. Yes, so that is why what Paweł said is the most important, that we've got a different approach. Yes, so he's more like thinking about how the process works. I'm thinking about the risks. Yes, so that is why our topics and our lecture will be divided, and you should receive information from these 2 perspectives. Yes.
Yeah, I think that's a great combo for today, and we hope that you will find the lecture interesting. And let me start with 2 definitions of cybersecurity, because lawyers define this phenomenon, cybersecurity. The first one comes from the EU regulation, so this is the EU Act of Law. It is from the regulation on ENISA. ENISA, we'll talk about this agency later a little bit more. This is EU agency that takes care of the cybersecurity topic within the EU. And the definition goes that we've got cybersecurity means the activities necessary to protect. And what protect? Network and information systems, the users of such systems, and other persons. So from my perspective, basically we've got devices and people, and we protect them against cyber threats. This is the definition. This is kind of simple. And also cyber threat is defined within this document, within this regulation. Cyber threat is circumstance, event, or action that could damage, disrupt, or otherwise adversely impact the network and information systems, users, and so on. This is the definition coming from the EU legislator. Basically, protection against threats, something unlawful. And just to have the reference point, I'm going to present definition coming from the Polish Act of Law. We've got here Act on the National Cybersecurity System. This is Polish transposition of EU directive. And the definition is a little bit more complex. As you can see, we've got resistance of information systems to actions violating. We've got confidentiality, integrity, availability, and authenticity of the processed data or related services. So I'm kind of exhausted reading this. This is a little bit more complex, but I think that there is a common ground with these 2 definitions. We've got here resistance, there was protection against, we've got violations here, there were threats. Simply common thing, but this definition also tells us a little bit more that the topic of cybersecurity, from my perspective, legal perspective, is really crossing paths with GDPR sections, General Data Protection Regulation. I think at the moment all people are experts on this topic, but this will be important later. Closing the definition thing, we've got cybersecurity defined, protection, resistance against threats. And now we start with the regulations, the first part of today's topic. What are the regulations of the cybersecurity systems? While preparing to this lecture, we asked ourselves, or maybe put ourselves into the shoes of IT company and asked how the company, how IT specialists can know what are the requirements and from which sources they can learn how to be in line, how to stay on top of the regulations regarding cybersecurity. And the legal literature presents distinguishing here for the three sources. We've got generally applicable regulations, we've got soft law, and we've got grassroots activities. I'm going to develop each of this topic right now, but just to tell briefly what's going on here, we've got the first one is simply the law that is established by competent authorities. Competent authorities are the ones who are in force to provide legal provisions to establish the law. We've got, and you can learn that we've got these competent authorities can be national, so in Poland it is basically the parliament. It can be international. In terms of EU, there is also EU Parliament and the Council. Competent authorities establishing the law in which there are regulations regarding cybersecurity systems. We come back now a little step closer from the third floor to the second floor. We've got soft law. Soft law are basically guidelines, recommendations, best practices provided to the world by regulatory authorities. Regulatory authorities are like ENISA agencies that were brought to life by the competent authorities. I will show you some of the examples of these regulatory authorities, and they provide best practices, guidelines, recommendations. Jędrzej will develop the topic because following these soft law regulations can help IT specialists provide that they are due care, that they did everything good. Also IT companies. This is really important. This is not a strict law, but really important thing. And the third source, grassroots activities. The name is kind of tricky, but this is simply internal policies within the companies. At the end of this circle of life of the law regulations, there is a company, there is IT specialist, in terms of IT company, that provide within its organization internal policies.
Yeah, Paweł, if I interrupt you.
Of course.
Yes, the two of them, the soft law and grassroots activities, are the most important for the IT specialists and for the company to provide, yes. Both of them should be informed about the regulation, especially internal regulations, and we, of course, are discussing and giving you the topic on the basis of the Polish law, but more or less is the same in the whole European Union, yes? So for the IT specialist, it will be the most important to know what are the internal regulations of the IT company, and for the IT company is the most important in the meaning of the cybersecurity incidents to learn their specialists about the internal regulations, yes? So it is less the generally applicable regulations, but more the soft law and the internal regulations, yes? And why we are talking about it? We are talking about it just to let you know that, of course, for all of employees or B2B contractors, it is not very interesting to learn the regulations. Yes, we know it. Yes, of course we know it, but we should do it. All of us should know what are the internal regulations of our organizations. Yes, sorry, Paul.
If we've got at the end the IT specialist, IT entrepreneur, of course, the first thing that he should keep in his mind is to follow the internal policies. If we look from the perspective of the IT company, of course, there is much more to be interested about. Then the picture should be broadened up to these three sources. And we will try with the first one, generally applicable regulations. I presented here some of the examples of these sources with general applicability. I divided and going to present you three things, say a few words about coming from the EU law. Polish law is simply just to indicate that the Polish legislator followed the instructions given them into the first directive. Maybe a little bit legal fun fact at the beginning. There is a difference between directive and regulation. This is more legal thing, but when EU entities, EU competent authorities provide regulations, document that is legal act, regulation simply has general applicability, application. That means that it should be binding in its entirety and directly within member states of the EU. When we've got directive, this is something more precise. EU competent authority provide the member states with direction, provide them with the instruction how and what topics should be developed, should be established, but give them margin to do it on its own way. So this is as to the result to be achieved. And we've got three acts of law here. We've got two directives and regulation. The first one is the directive, the first legal act regarding cybersecurity, so show some respect to the NIS. Unfortunately, this is going to be deleted soon by the third legal act, this younger sister, NIS 2. But this was the first one, and it provided, among others, three things to the IT world and requirements to the cybersecurity systems. The first one was the obligation to EU members to somehow organize its own national strategy on security of IT systems. So the EU legislator said to the countries within the EU, please organize national systems. The Polish legislator did that. We see that 2 years later we've got Act on the National Cybersecurity Systems. Good. The second thing coming from this directive was organizing a computer security incident response teams network within the EU, within each country to cooperate while cybersecurity becomes international. Also, in the Polish Act, it was established. It was a transposition of this directive. And the third thing is creating and choosing that some entities, private entities, companies, private or public, the most important thing was what is their business activity. But they were divided to the operators of the essential services and digital service providers. And EU legislator put on them requirements. We will talk about it also. The second one is regulation ENISA, Cybersecurity Act, means serious. And this one was to establish ENISA, this EU agency to protect, to organize best standards to protect against cyber threats. And the third one, we've got this new directive, as I said, younger sister of the NIS, coming from the December 2022. The countries from the EU members should adopt proper regulation until the October 2024. And just to tell you that these operators of essential services and digital service providers were kind of re-established, simplified. Now the EU legislator told that we've got only essential entities and important entities. They are, of course, required to be in line and follow cybersecurity. Just to give you information about the essential. Essential are the market standards, areas coming from the energy, air, banking, finance, health, water, digital infrastructure, public administration. And important ones are organizations focused on waste management, chemical products, food manufacturers, digital providers, and so on. The main difference will be that the important ones are a little bit less important than essential and will face lower financial penalties and will be up to the reactive supervision as opposed to the essential ones that will be too proactive. This is it, and the fourth is simply our Polish transposition. And what we've got here we come with the second source, as I mentioned previously, soft law. And soft law, as I mentioned, are guidelines and recommendations coming from the regulatory ones. Here it is indicated in the literature that banking sector should be somehow emphasized because of its, let's say, activity concerned and regarding the payment terms, cooperating with third parties. This is a little bit more specific. And other sectors, I just put examples of the other regulatory entities. We've got ENISA first. I showed that even it can come outside the EU. We've got Federal Trade Commission also on the US competent body to provide with legal instructions. We've got President of Personal Data Protection Office. This is Polish regulatory entity. So these are, for example, the agencies that provide with the soft law matters. And the last one are the grassroots activities. So as I mentioned, these are some kind of inspiration. The company can use this Sherwood. These are frameworks, methodologies that can be used while we are a company and would like to set a policy on the security matters or asset management. I bolded.
And Paweł, why we're talking about it? We are talking about it just to let you know where to search for some general rules. Yes, so that is why we are focused and giving you some kind of regulations from that bodies. Yes, just to let you know where to search for the specific regulations. Yes,
exactly, because these are, I would say, private best practices, corporate practices, but their impact sometimes is so deeply, achieved that ISO is even mentioned in the directive NIS2 for the 4th time. So ISO is standard, probably all of you know, and you can learn from ISO how to implement cybersecurity requirements within the company. So this is the third source. And ending the regulation part of this lecture, one more time to wrap up the idea. We come from the generally applicable provisions to the individual person. This is the, let's say, circle of life of legal and non-legal sources. We've got law sensu stricto, then we've got its transposition to the country, then we've got the organization, IT company or no IT company. Company from the essential and important entities that should follow previously mentioned requirements, and in the end, as Jędrzej mentioned, IT specialist who should be updated with the IT requirements within the company that he's cooperating or working for. So these were the regulations. Simply, floor is yours.
Okay, so if you thought that that was boring, now it will be really boring. So, because my part is to describe or discuss or give you some kind of examples of the regulations, well, based on Polish law, because I'm Polish lawyer. So the regulations which are concerned or concerns IT companies and IT specialists. Why? Why we are talking about it? Yes, because when we were preparing with Paweł to this lecture, we studied the cases, yes, and in most of the cases, the bottom line, so the issue why some kind of cyber security incidents happens, goes to the natural person, to the physical person. Yes. So in the end, the problem is always the human being, yes, who is, I don't know, opening some kind of attachment which is interesting for him. Like, for example, the best known example is an invoice, yes. If you receive an invoice, yes, the attachment with the named invoice, yes, everyone is, interested why it comes to him or so on, yes. Of course, the same is with phishing. Yes, I was also attending the lecture 1 week ago about cybersecurity, and all of the data shows that phishing is the most common, we can say, cybersecurity incident nowadays. Yes, so not even the ransomware, which are a little bit rare, but they happen. But the phishing is the most happens the most often. Yeah. So if we are thinking about the liability for the cyber security incident, we have to look from the two perspectives. Yes, from the perspective of IT company and from the perspective of IT specialist. Yes. From the perspective of IT company, because the IT company deals with the system, yes, and with the program, yes. It writes the code for the customer, yes. And the IT company is responsible towards the customer, yes. IT specialist is responsible towards the IT company, yes. But very often, their liability is the same. Why? Because very often, IT specialist is employed on the B2B contract, yes? And IT company works on the B2B contract towards customers. Of course, it happens that also IT specialists are working on the employment contract, and the situation is a little bit different. On the Polish law, much more different. I will show you. So we've got 3 levels of liability: civil, labor, which is kind of civil liability, and the criminal liability. In terms of civil liability, here we've got few regulations from the Polish Civil Code. The first one, well, it shows in what kind of manner the debtor, so here IT company or IT specialist, should perform his work. Yes, so you see that it should comply with substance, and the work should be done in a manner complying with its social and economic purpose and principles of community life. And if there are customs, also the customs. So, first of all, what Paweł said, internal regulations. Yes, internal regulations which show us the custom in the IT company for the IT specialist, how he should perform his work. Yes, if there is a regulation, internal regulation, it can be a custom, but moreover, it can be an obligation. Because if you are employed as an IT specialist, you often sign. Yes, you sign that you were informed about the regulations and you receive a ton of paper. Yes, who read it? Who read it? Anyone? No.
I read it.
Me neither. You read it, but you prepare it. So someone read it. Yes, but you know, you should read it. You should learn it. And you should comply with it. Yes, this is the most important issue. Yes, but also the IT company should also cooperate with the IT specialist. The same as the customer with IT company. It should cooperate to allow the IT specialist or IT company to perform its obligation at the best way. Yes. In this article, you see, and I think that it's the same in most of the jurisdictions, yes, how the debtor should perform with due care, yes, like due diligence with due care. This is what we should do. Why? Because we all know that we cannot guarantee, yes, the cyber attacks happens very often, and probably the percentage will only go higher. So we should not guarantee that, for example, we will not allow any cyber attack, yes, because it is impossible to perform such obligation, yes. So then, if we are not guaranteeing anything, yes, usually it happens in terms of IT specialists, but sometimes IT companies guarantee such things, yes. But if we do not guarantee it, then we should do everything in a manner with due care, yes. So we should stick to the internal regulations, or we should stick to the agreement in terms of IT company, yes? Here, the next article, well, on the basis of Polish law, if you are a B2B specialist, or if the IT company performs its obligation towards the customer, if there is a cyber attack, yes, then the IT specialist or IT company has to prove that it was not done by its fault. So the burden of proof is on the IT specialist or on the IT company towards the customer, yes? It is very important because then we have to show that we are complying with the internal regulation or with the agreement with the customer, yes? The rest is not very important. Okay, this article on the basis of Polish law in Article 473 of Polish Civil Code, you've got the levels of liability. It may differ, yes, you may even oblige as a guarantee, or you can be less liable, but the lowest level of liability is the liability for the intentionally infringement, yes, yeah. From the intentional infringement. Here you've got the regulations regarding the employment contract, and here the situation is easier for IT specialists, of course, because employment only concerns the IT specialists. So here the burden of proof is not on the debtor, but it's on the employer. So the situation is easier for the employee, and the employee, if the employee causes the damage not intentionally, is responsible only for the 3 months remuneration, with the 3 months remuneration. If employee causes damage intentionally, he or she is responsible in full. And the last issue is the criminal liability. Why I'm saying about it? Why we are saying about it? Not to to scare you, but to show you that there is a common factor between the civil liability, labor liability, and criminal liability. Because in these regulations, you've got the most common crimes connected with the cybersecurity attacks. And in this article, you can see that you will not commit a criminal offense if you are doing anything on the system with the sole purpose of securing a computer system. Yes, this is one. Second, no penalty shall be imposed when you have immediately notified about the problem. Yes? And third issue is the aiding. Yes, that is a stage of committing a crime in the Polish code, in the Polish criminal code. And for the aiding, you are responsible if you have violated a particular legal duty to prevent a prohibited act. So if you are not doing something which you should do based on your agreement or the internal regulations, there is a risk of being responsible for the criminal crime in the stage of aiding. Yes? So what is the conclusion? The conclusion is that IT specialists and IT companies should follow internal regulations and agreements. And second of all, if there is an incident, cyber attack, so an incident, you should inform. So IT specialists should inform the IT company about the incident, and IT company should inform its customers about the incident. Yes, so that will should minimize the risk of liability, and for the IT specialist, the criminal liability. Yes, so these two issues are the most important for you to remember from that lecture: due care, internal regulations, and information about the incident towards your employer and towards the customer. Yeah, Paweł, the floor is yours.
Yep. Thank you, Jędrzej. This information thing and due care is important, as we said, from the cybersecurity legal perspective and also from the GDPR perspective. Because if you, for example, cooperate with IT company on B2B contract, you also provide with data processing agreement. Slightly different topic, but still really attached to the cybersecurity idea. And there is also, should be obligations to inform about some kind of leak of information or violation of data processing quickly to the administrator of the data. Administrator will be, of course, the IT company that is hiring or cooperating with you. So this is, I'm going to emphasize this one more time. From the IT specialist point of view, information should be provided quickly. Due care also should be, of course, on our everyday tasks should be followed. Coming to the third part of our lecture, because we introduced you to the sources of the requirements. Jędrzej introduced you the rules of the liability, both IT companies and IT specialists, telling you even something about criminal aspects of that. Now we come to the third part, and Jędrzej also touched the dispute case studies. Now we come to the latest part, this is practical management. Practical management, I think, is most familiar thing for you, and I believe in this room there are people who know the topic even better than us, because this is more up to the IT guy or internal, external, depends on the size of the company. But there is a standard nowadays that the company distinguishes, hire somebody who is Chief Information Security Officer or admin IT system, the person within the company that handles the topic internally. Here is the example, because examples are everywhere, but I presented you the one coming from this first source. This is the most important source. The level source, the highest is EU. This comes from this directive NIS 2, as I mentioned previously, that the Poland and other EU companies have 1.5 years to make a transposition to the Polish. And here are some, maybe not examples, obligations for these essential and important entities to provide, to establish, to enter these policies within its company. I think most of them you already know, you heard about them. We've got policies on risk analysis, we've got incident handling, business continuity, really important during COVID-19. My perspective as a lawyer, the clients of the IT companies ask the companies how you deal with the business continuity matters. There is a COVID. Are you be able to provide services to us? Where are your servers? Are you using a cloud? This is really important. It was really during the COVID-19 the top topic from the clients asking, please provide us with information on your business continuity. We've got supply chain, security in network, policies, and so on. So when I prepared to the practical management, I heard a word from the people from admin IT, and I would like to say hi to Wojtek and Tomek if they're gonna decide to watch it. And I have a chat with them, and I understand that I should stay with the legal perspective here because encryption of disk and VPN and so on, this is more your knowledge. But I'm trying to say in terms of the practical management that first of all, we should take care of the size of the company, of course. When it's bigger, I think the team should be provided within the company, maybe external auditor. If there's a smaller one, even lawyers can take care of it. Sometimes when it's up to 15 or 50 people, we've got some idea on the security policies, but there is also a necessity to have the guy who understands the idea, who knows the company. So size, it's business activity, of course, as we mentioned. If we have a bank securing the payment, there is a different topic than selling plants or whatever. So business activity of the company is also important thing to start. Organizing requirements within the company, practical management of the company. The second thing that I already mentioned, there is a necessity to have a guy, expert, maybe CISO one, so Chief Information Security Officer, or external one, but the one person or one team that in the case of emergency and understands the security policy. Lawyers, I think, I recommend should be involved into the process of organizing security systems within the company. One is for the regulations that I already mentioned. The second one, GDPR ideas. There should be also precise terms upon which the notification should be imposed to the administrator. In the team, I think the board should be involved. Of course, the executives of the company, maybe some kind of director who understand the operations of the company. So it is not one-man job to organize security policies because in the end, the IT specialists are gonna read it and they will have questions. Why this? Why that? I'm not sure if I can do it. I do not have device. Is it possible to work on my computer? Now companies, I think that are cutting this option, bring your own device, or if they agree to it, there should be MDM system, mobile, maybe not MDM system to let these IT security teams make an intervention in terms somebody, for example, has stolen its laptop or do not have it. So this is now a common thing. Another recommendation for practical management, if you are not such a big company that you are upon this essential and important entity provided in this directive, you can search for something what I mentioned also previously. Soft law is really cool. I'm going to say a few words because ENISA provides easy to implement instructions. I can read them with you. And also you can, I think, use the ISO standards, have the audit and be in line with them. And just to have a look of something more about practical management. Now it's just to tell you that this, let's say, ISO thing, I want to show you that it is, I would call this private, but really nowadays spreadly known corporate standard that even, I highlighted it in the gray, is mentioned within the NIST directive. So this has huge impact on the market. And here are coming from the ENISA regulation, easy to understand, easy to digest, even for non-technological guy like me, how we can react in terms of the cyber threat occurs. I agree with Jędrzej that phishing nowadays is quite popular. The companies that I have worked in the past, there were examples, email from CEO, come to see me, I need to talk with you, or invoice I have even in my personal life situation, like some entity send me invoice and please pay me. So, and let's see what ENISA says on this topic. We've got issue, phishing categories and recommendations. In terms of people, so also HR people should be involved while implementing practical management within the company. Employee awareness, so policies, cybersecurity training, cybersecurity policies. We have spoken about it. Process, we've got incident planning and response up to the IT guys within the company. Technical also, this one I'm leaving to IT specialists, IT engineers. Somehow make the, I think that the encryption of the disk is basic stuff that should be implemented within the company. We've got web-based attack, categories, recommendations, general malware. This all informations comes from the free to download information coming from the ENISA website, and I'm sending you there. We've got also malicious insider, denial of service, social engineering, stolen device. Stolen device, yeah, this is really common thing. The first, of course, it should be secured. One thing is the disk, the second one, proper password, and so on. This is all from me, Jędrzej. If you would like to say a few words from your perspective.
No, I think that we may ask our audience for the additional questions. Maybe something was interesting for you, or something was not clearly said. Yeah, so please ask questions.
We covered these 4 ideas. Maybe you have questions. Yes.
Please.
Thank you for this presentation.
Sorry, microphone maybe.
Thank you for this presentation. It was brilliant, in my opinion, but I am software developer specialist, IT specialist, and from the first sight it could happen that it could be boring, but not, because I realized a little bit what is behind the scenes. Because, for example, I have been working for EY, and in our company there is big InfoSec tests, questions and everything what is connected with that, and I realize that behind the scenes there is criminal issues and etc., and we have to provide everything what is the best for this.
Yes, from the criminal liability, it covers also the management board. It is always, the most important is to stick to the internal regulations, yes? Because if someone is searching for some criminal liability, it checks the internal regulations and it checks the behavior of the human, yes? So covering the internal regulations is the most important
Yep,
thing.
and we have one more time, step by step. We've got internal regulations that also should be in line with the law. So all ideas are mixing. As I mentioned, GDPR, data processing. I think there can be another lecture, GDPR versus cybersecurity. So I also appreciated that Jędrzej came up with idea to talk about the criminal aspects of this idea, because this is not so commonly discussed.
Yeah.
We are more curious about, of course, liability in terms of the money, should we pay or not pay, but there is also a criminal aspect behind it. And
yeah, because you have to be aware that at the end, who will go into the case? The court will go into the case, and the court is not the IT specialist, so the court will take the expert witness, and the expert witness can be your colleague, it can be a guy who is on your level, yes, but it can be someone who is, outdated and knows very little about the best practices nowadays.
Yeah.
Yes. So we have to be aware about it. Yes. And if we stick to the regulations, yes, internal regulations, well, we are covered. Yeah.
Majority of companies don't pay particular attention for the security, but we sometimes got angry if we have to devote, for example, 2 months for InfoSec. But
Yeah.
it's needed, yes.
Yeah.
Yep. Yeah. Something more
Please.
we've got here.
Yeah, I have a question actually, a really interesting one. Have you ever experienced the situation where the clients, you have an IT company and we have a clients, and you read the contract from client and you see that he really trying to play with you some tricks, some really, not common things.
I never do it.
Every time. It happens every time. No, it's
Yeah,
really common.
yeah.
This is why we have a job.
Well, this is, the bottom line of negotiations. You always are willing as a lawyer, well, not maybe always,
Not
but,
always, yeah. But
you
secure-
try to put more liability on the other side. Yes.
The first example, Jędrzej mentioned this. If the client start with his lawyers, with his template, would like to start a cooperation with IT company and provide its template. So
Yep.
of course, maybe not of course, but it is highly probable that he will start with you, our IT provider, will guarantee that no viruses, no malwares, not anything will happen, occur within
Yeah.
the project. This is the starter. Not always. This is not a standard, but
Yeah.
sometimes happens. So then me and Jędrzej read this contract and address this. Maybe not guarantee. Maybe we will try our best, put best
Yeah.
endeavors. We'll cooperate with you. Maybe we provide some, this is also common ground, happy medium to meet with the client and IT company.
Or we limit the liability,
Limit
quotes, yes, for special cases, yes, so that you are aware that, for example, you guarantees for the, I don't know, for the phishing, maybe not phishing, but for the malware, but
Yes.
not for the phishing, yes, and so on, yes.
Give some time to response. For example, okay,
Yeah.
client, if you want us to not guarantee but place our best endeavors, please give us a time to, react. Give us, for example, 1 week, 3 days, 2 days.
Yeah.
Of course, this is negotiable. But
Yeah.
first, inform us, show us where, because this is also obvious that the client would like to say, if there is a problem, the bug in the code, we are not happy and you should pay damages. So then I think lawyers should say them, you should specify where is the bug, on which stage it was it, and so on. So this is, because your question is really broad. Yep, we see that. And of course, both parties are reasonably negotiating this, and even the lawyers from the client side understand that guaranteeing is not a common
Yeah,
standard.
but Paweł, now we see after 5 years of GDPR, yes, that the situation on the legal market is, we can say, normalizing, yes, because both parties know how the regulations works, yes, and it is very different than in 2018, yes. So we can say, even on the market, the common or ready to implement drafts of the regulations connected with GDPR, and I believe the same may happen in the future, in few years' time, in terms of cybersecurity. Yes.
If the client is not happy with the response coming from the IT company that would like to provide services, maybe we should go for the service level agreement. Maybe let's leave this at this stage guaranteeing, but maybe go with the service level agreement, something different. So this is all up to this.
Awesome. Oh, sorry. Yeah, is it working? No, I think. Oh, yeah. Sorry. Yeah, that's awesome. Really, it sounds like the clients are trying to put responsibilities on the IT company, and the company will try to protect himself. Yeah.
Yep.
Very nice. Thank you very much.
Yeah, but that is why it is good that on both sides, yes, from the IT company perspective, usually there is an IT specialist who is working on it, yes. But it is good that from the perspective of the client, that there should be also IT specialist working on the agreement during the negotiations, yes, because then it is your colleague, yeah, maybe he will switch sides, and he will be aware that he may in furious time be on your situation. So it should he should be more, we can say, try to understand the other party also better. Yeah.
Thank you. Something more?
You've got a question.
I would like to ask you, what's your role as lawyers in this process? You prepare and negotiate contracts before any cybersecurity attacks happens? Or also, do you have any role or responsibility after any attacks happen, right?
Yes. He's preparing agreements, I'm fighting for the cash.
Okay, no. So...
Joking.
Okay, we can, of course, we are involved, of course. Maybe I will answer and stick to this internal role of myself in STX Next. So, yep, me, our legal team, also best regards, are involved in every unlawful situation happening in the company that we are cooperating with, even if it's before or after. So, in terms of the before, yep, we are reading policies, recommending them. I think the last word is for the IT specialist. We try to put some, legal nice wording here, but the material is strictly technical. In terms of the after, I would say that this is a place for our expert within the company from GDPR that covers the topic, covers the idea to fulfill the obligation, because in GDPR there are precisely put time margins for letting know the regular entity about the incident. This is really important. The company, every time when the data breach, unlawful violations happens, have to do something with it. There is obligation. One thing is to inform the officials. Really important thing, because it can happen that after this notification, really brave notification, the regular entity will enter the door to the company and say, okay, let's speak. But if the company decides, also based on the best practices coming from ENISA, that this is not so severe, that it only touched 2 individuals, then it should, in its own books, write that there was incident. We decided not to let officials know, because from our perspective and on market standard, this was not severe, but lawyers should really be near around these situations.
Yeah, usually these tasks are now in the companies dedicated to compliance officers. Yes, so the people, usually lawyers, who are responsible for the, you can say, for the organization as a whole to comply as strict to the law, regulations, and non-legal regulations. Yes, yeah. So but like Paweł said, very often if there is a severe accident, yes, then very often it goes to the external advisors who search for. Depends on the site, maximizing or minimizing the risk.
Because it goes like this. IT specialist acquainted with the knowledge that there is cyber threat. He, as a processor of personal data, needs to inform administrator, IT company, within exact period of time. And then administrator decides what to do, notify officials or not. And lawyers should be around. One thing is compliance, and also within our expertise, within our knowledge, there are also GDPR experts that are strictly reading one regulation, of course, EU, but they are really fast to react in terms of the incidents. Yep, so we are around, yeah. Thank you.
Any other questions?
Okay.
Okay, I have some kind of question about how should we act as a developers or QAs in a situation, because if we enter a new company, we often sign some kind of agreement that we should not speak about solutions, security solutions, which we applied for a client, and then we switch to another job, start a new project, and we start making decisions about solutions for the new projects. And in aspect, when we have meeting with all team, we often use some kind of
knowledge
statement.
Yeah.
And you know what? We've used this and these technologies, and you as a how do you see it as a lawyer? If it's leakage or leak of
Good question.
information.
Very, yes, it happens very often. And you can use your knowledge, yes, but you should not reveal the information which should not be revealed. So you can say about the process, how you see it, yes, from your perspective as a specialist, yes, but you should not refer to the specific client, yes, and if there is any kind of factor which is precisely used in your previous job, you should not reveal it, yes, but the process, you can, it's your knowledge, yes, and you can use your knowledge anywhere else.
Yeah, probably you will have some NDA agreement with the company, non-disclosure agreement. You can go through it, the intention probably of this document. This is standard, this is not something tricky, but probably this is going to cover you with the broad obligation on keeping silent of your specifics of the previous project. But as Jędrzej told you, and to cheer you up, we as lawyers also have to keep secret of our clients' information. So this is not that we have one deal and we cannot use what we learn on the deal, because as you as a developer on every project expand your knowledge, we also have our knowledge from the previous cases.
Yeah, but there is not only the issue of the information, but also the unfair competition. Yes, so you should be careful, but you can always use your knowledge. Yes,
yeah. Exactly. Not specific that we did this for X, Y, Z, we did it this way, but saying that I'm using this technique, I know it from the past, I learned it on myself, so this is not a problem. But of course, do not provide with specifics of other projects.
Yeah.
This is not yes or no question, but be reasonable with that, with using your knowledge, not informations from the exact projects. Please.
Please.
Just to build upon the thread that he just started, I mean, number one, yes, there is this knowledge drain that happens from company to company. But forget about this. Forget about a person joining another place. There is a hell lot of information that gets leaked through a resume, a CV. When someone applies to a job somewhere else, there are CV points which they write in their resume. I've worked on this.
Yeah.
And that becomes a source for another company. You never know about it. Yep. So do you recommend some kind of a checklist or a guideline or something that any individual should run through so that they can avoid such kind of leaks?
I would like to see this because I know that there's something similar. There are blind CVs in your market, that there is hide information on the name and the surname of the IT candidate. But in terms of the resume that you're sending, I would rather, I would really start with reading NDA with the company from the previous, because maybe you signed the obligation to not disclose the name of the clients. I think this is really probable. This will be a problem for you because there are some projects, it happens, that the client should even prohibit letting know that the companies cooperate. So this is not something good for you. You would like to brag about it, that you work with big company. That's unfortunate. Then you can, as Jędrzej said, go a little bit round about it, not too specific, but saying that I cooperated with the company hiring thousands of people.
Big tech company.
Because, but not giving to recognize. But I understand you. This would be problematic, and in your career, this is also discussing when you join a company.
Yeah, but if you are looking from the risk minimizing approach, yes, then, like Paweł said, if you have signed any NDA agreement very specifying what you should not reveal, then you should not write it in your CV. Yes, because then there is a paper. It is, sent via yes. So there is a proof that you have revealed it. Yes. So better not to do it. Yes. Like Paweł said, go around it. Try to write any round sentences about it, but not going into details. Yeah.
There are some trivial situations in terms of the non-compete clauses, because this is also when two IT companies would like to cooperate, because one has technologies that other don't have. There are some trivial situations that I'm on a call and we know that both parties somehow couldn't, say it, but we go around it. This sometimes happens, but this is serious business and it should look this way. we keep our response on some kind general level. If I were on exact project, see your resume, go see your NDA, I would tell you more specifying how could you behave. But yeah, you should be careful because as Jędrzej said, sending an email with resume is sending an email with resume. It was sent.
You may say you don't want to reply.
One more time, please.
Sorry for that, but maybe a specific question you may say that you don't want to reply, but just wanted to know, in your career, have you come across such an incident where a company has held a candidate liable for leaking an information through some kind of means?
I've got such situations, yes, but I recommended my client to leave it, yes, because it was, there was no proof, real proof to go to the court. So, and especially on the grounds of Polish courts, yes, for the judge you have to have, I don't know, a banner that
yes.
there was, there is a liability.
Yes.
Yes.
I will add two perspectives to this. One is just simply bragging about cooperation, publication. Then I recommend always to my client, please confirm with the company, even if it's in the contract that previously was written. Please confirm one more time that you would like to put it on the website that you cooperate. This is the first thing. And answering to your question. In my career, there were some disputes at the stage of, let's say, pre-court, that somebody sent, threatened via email that we see that you said too much, but it never came to the court. NDAs disputes are not so common. This is a pain in our necks to negotiate NDAs.
Okay, Paweł, but when you are speaking about it, I reminded that 2 years ago I was writing, I think that even with you, Paweł, the opinion about the leakage on the basis of the NDA. And the other party, though there was not good proofs, went to the court. And they received in the first instance the verdict, the ruling granting them 120 million of zlotys, just based on the NDA agreement covering the issue of negotiations before the transaction. But it was not on the referring to the IT specialist, but it was referring to the M&A market, yes? So, but it was based, the dispute was wholly based only on the NDA agreement, yeah? So, sometimes it happens, and if it goes to court, then you lose the force on it. Yeah.
But NDA stage is always. But now there is a solution. Most companies join some kind of idea of making unique NDAs. There is a program, One NDA, that companies are trying to implement because there is no such need to negotiate it so much. Let's focus on the business.
Yeah. Yeah, that's great perspective. Yeah.
Thank you.
Yeah?
Yep. I think we are
done.
closing right now. We are done. Thank you very much. Thank you for your question. We even 1 hour it took. It's 1 hour right now. So thank you very much for joining us. Thank you, Jędrzej, for speaking with me today.
Thank you, Paweł.
Yeah.
It was great.
Thank you very much.